Thank you, Michael, for that introduction. Mr. President, honorable judges, distinguished visitors, friends and guests, let me first pay a few acknowledgements, beginning, of course, with our host, Singapore Management University. This is a great new law school whose first graduates have already impressed local and offshore law firms during their internships, including mine, and they will undoubtedly make a difference to the development of Singapore's legal landscape in the years to come. Second, he co-sponsors Herbert, one of the world's great international dispute resolution firms. Unfortunately, because they appear before me not infrequently, I cannot praise them too much for fear of losing my objectivity and neutrality. Now, the only thing I can safely say about them is they make these fabulous roller ball writing pens. They are the smoothest writing ball pens I know, which is very useful when I have to take notes of counsel submissions. Now, it may be that this virtue in this pen is born out of necessity, because some of you may know that Herbert Smith lawyers talk pretty fast. And Michael Firmston, it is such a pleasure to be introduced by one of my old teachers from Oxford, from whom I must say I'm still learning, and who is my role model for how to lead an active and fulfilling role beyond the age of 78. If you think I'm old, then have a look at him. That's what I want to be like when I get to 78. I hear on the grapevine that this establishment of the Michael Hwang Prize for International Commercial Arbitration has largely been funded by former members of my chambers. My heartfelt thanks go up to them for this wonderfully appropriate gift. For young lawyers in the early years of their careers to donate hard cash in commemoration of their former mentor is the sincerest form of thanks and appreciation I can think of, and I'm so touched and thrilled that I have been able to inspire some of the brightest young minds in the Singapore arbitration landscape to contribute to the growth of this challenging and fulfilling practice area by attracting future generations of young lawyers to the serious study of this subject. Coupled with that last expression of gratitude is the debt I have to acknowledge that I owe to my co-author, Kevin Lim, who has done a magnificent job in helping me prepare this paper, so much so that I've decided we have enough here for 2 papers for publication in 2 separate journals. Kevin is among the brightest and most hardworking of a number of bright young lawyers that I have been fortunate to have had as my associates. And the good news for the hiring partners in the law firms in this audience is that he will be available for employment by the middle of next year after he finishes his stint with me. Let me now make some preliminary remarks. You will see that I have handed out the text of my paper, which I emphasize is still in draft. It is a work in progress, but there is already too much that I can discuss in an hour. I therefore propose to concentrate only on the following core issue, which I think will be of the greatest interest to this audience, and that is the problem of identifying corruption in agency agreements and deciding on the consequences of corruption when so identified. So I will be concentrating on the impact of corruption in international commercial arbitration. And just for your future reference, you will also find a hefty chunk of this paper, which I believe all of you have copies of, in draft, is devoted to the position of corruption in public international arbitration, especially in treaty arbitration. As I said earlier, that could make a paper on its own and deserves a separate presentation on another occasion, but in the meantime, you are welcome to the fruits of Kevin and my research. Let me now proceed with the lecture proper. As you see from the first slide, the lecture is not about fraud or illegality as such. It's about corruption in the underlying transaction, which is the subject of the dispute that is submitted to arbitration. Now, there is not a lot of dispute about the effect of corruption on the part of a tribunal member. It's uncontroversial that awards rendered by corrupt tribunals are liable to be refused enforcement, set aside. And Singapore, Australia, New Zealand, India and Zimbabwe, for example, have specific references in their arbitration statutes to say that awards which are infected by fraud, corruption, will not be enforced by the courts. Other model law countries find refuge in simply relying on Article 34 of the model law, whereby awards can be set aside on the grounds of public policy, and all civilian lawyers will agree that corruption will come under that head of challenge. But common lawyers, of course, like to see things in black and white, and so most of these countries have set out specific references to corruption, which procured the award, which is what I'm not going to be talking about today. We now move on to slide 3, I think. Yes. Just to start off with, get some idea of what we are talking about. Taking a fairly conventional definition, Article 15 of the UN Convention Against Corruption, which is fairly recent in 2005, you will see that these definitions are, of course, two sides of the coin, one viewing it from the perspective of the bribor, and the other viewing it from the perspective of the bribee. The emphasis you will see is on the word undue advantage in both cases, which is a lot of help. And the interesting thing is that the test of the prejudice that occurs is when the official who is bribed, he commits an act or abstains from an act in the exercise of his or her official duties. Now, I'm not going to spend a lot of time in this lecture discoursing about the nature of corruption. Just to give a plug, the Law Society is staging a criminal law conference, I think in mid-October this year, where I will be participating in the session on corporate crime. I expect to be giving some views on that in that platform. But for now, let me just point out one thing. Most definitions of corruption do not distinguish in the result that occurs as a consequence of the bribe. In other words, there is no distinction between bribing a person, namely a civil servant, to do something which he is actually paid to do. He wants either not to do it, treat it as a matter of his discretion, or he wants to take his sweet time about doing it. And many people in this region and elsewhere consider it appropriate or even necessary to grease the palm to get what they think is their entitlement. Contrast that with giving a bribe to persuade a civil servant to do something which either he's not supposed to do or which he has a discretion to do or not to do, depending on the merits of the case. And the money is there to put aside merits and make it decide in favor of the bribor. Now, there is no distinction in most definitions of corruption between those two kinds of bribes. And if you look at slide 4, you will see that point reinforced by the Singapore examples. I give you two definitions, one from the Prevention of Corruption Act and the other from the Penal Code. Again, this is simple definitions of if a public servant does or forbears to do anything as a result of getting gratification. We won't even go into the definition of gratification, but that's another story. 163 of the Penal Code is interesting because it's a Singapore statute. You might think that it only concerns Singapore domestic law. That's actually not completely correct. As you know, the Singapore Penal Code is taken from the Indian Penal Code. Many of the cases where corruption occurs takes place in the Indian subcontinent. So you have a whole bunch of countries out there with the same penal code. And you can extend that to East Africa, where many of the former British colonies are also adopting the same penal code. So if you know Section 163, it is applicable to many, many countries.